must agree, can agree. These are different concepts. I don't have to agree to waive the restraint. I can say, no, actually, I've invested a lot of money in this formula and this technology, and I want to keep it as secret as possible until I'm ready to launch. So I cannot waive that restraint. You can't go work for Google, or for MTN if you're at Vodacom, that sort of stuff. That can happen. But if it's I'm working for a furniture store and I've got a restraint, and that's all I know, and I want to work for another furniture store, then I can ask for the restraint to be waived, and probably going to be considered in the factors when they consider the fairness of the dismissal. Here's a question in this context: can online consultations have an impact on the meaning of a meaningful joint consensus seeking process? Look, during the lockdown, it was impossible for people to meet face to face. Meetings weren't permitted, so the virtual went on the rise, and we've had virtual consultations for 189 consultations. So that did happen. The quality of that interactions really determines whether or not it's meaningful. But right now, I can have a meeting. So if I can have a meeting and the employees say, we want a face-to-face, we don't want to do the virtual thing because we want to look you in the eye and we want to make sure that this is right, whatever, excuse me, that can play a role as to whether or not the consultation process meets the requirements. So there's no rule of thumb that says this is in and that is out. It just depends on the circumstances of each case. I know that's not an answer that most people like, but you've got to look at everything within the context. During the lockdown, the context was no meeting, so virtual consultations was almost a given. After the lockdown, when meetings are possible, but they want to have the virtual, it depends again on the context. It's not going to be decided completely one way or the other. Before I move off from this section, let me just see what's coming next. Well, we talk about the onus first. So before we talk about the onus, let's just wrap up our 189 discussion. The consultation process will also involve a discussion about the timing of the dismissal. So if I consult with you today and I want to retrench you by Friday, then the issue is going to be why this unseemly haste. And if you can't justify it, well, then it's unjustified. It's probably going to be an unfair dismissal. But if it's I start today and I say I want to complete the entire process by the end of September, that's not putting any dates or anything. Just I'd like to complete by the end of September and I'd like to start the notice month of October. That's not unreasonable under those circumstances. The timing, can be an issue. A lot of the time, there was a comment about trade unions wanting to delay things, it is so that if I believe that if I delay your retrenchment, I can get another month's notice or something along those lines. Then your job as the practitioner acting for the employer is to put a stop to that and say, no, the consultations will end. I will schedule the consultations 12 hours a day on a Saturday and a Sunday and a Monday and a Tuesday. We'll stop production. We'll do nothing other than consult. You can get that process going. And so the timing of the dismissal could take on a hue of its own, depending if it's a very short period. Now you have to justify it. If there is no option on the timing, they're inflexible, but they can't provide a reason, probably going to be unfair. So again, it depends on the circumstances. So timing of dismissals, the number of employees needed to be dismissed, it's also a consultation topic. So if I need to save 2 million Rand a month and I've got 4 employees and they all earn 500,000 Rand a month, then just by retrenching 4 employees, I can limit the number of dismissals to 4. But if I want to retrench 200 employees because they all earn a little bit less, the number could make a difference depending on what they do. So the 5 employees earning 500,000 a month could be super duper, and without them I can't make 10 million a month. Whereas the 200 employees, they're all packers, they earn minimum wage. By doing that, I can get to my number. Then 200 could be justified under those circumstances, even though there was a lesser number available to me. But it's that kind of discussions. It depends on the circumstances of each case. There isn't a general rule. You've got to have a look at all of those things. Part of your disclosure requirements is you've got to disclose how many employees in the past 12 months you retrenched. Why? Because it could be an activation point for Section 189 capital A. So if I've dismissed 48 employees in the previous 12 months, and now I want to retrench another 6, that's going to be 54 in a 12-month period, which means 189 capital A is activated. So that could be critical. So you've also got to disclose that sort of numbers. And when an employer comes along, especially a large employer, and they say they've retrenched no one, you've got to look at that with a lot of skepticism and ask the questions. Because if things go down and it turns out that you could have asked a question that would have revealed actually there was restructuring that had happened, and there were retrenchments that followed, and you didn't stick it in the letter. Imagine losing a case because, well, you forgot to ask that question. So read Section 189, read 189 capital A if it's a large-scale retrenchment, and ask those questions. The sections are there. They're very easy. The big thing is the mechanical checklist approach. Don't go with a tick box. They've actually got to have meaningful consultations and discussions around those issues in a joint consensus-seeking process. So the joint consensus-seeking process doesn't mean that there must be agreement, just that you must seek to get the agreement wherever possible. And if you can agree on certain things, like, we completed our consultations at 2 o'clock on the 23rd, there's no need for anybody to do any work after that. They can all just go and polish off their CVs and use the business machines to go for interviews and everything else. That's an agreement. So that's one little, you can hang your hat on a partial agreement. It's going to make it harder for them to contest the fairness of the dismissal where you have made concessions along the way. I always encourage my employers to make concessions, especially the ones that cost no money or cost very little, because it does make them look good in the next round, which could be Labour Court scrutiny on the process. Any questions or anything that you want to raise around this topic? It is a fascinating topic and we can spend the whole day talking about it, but I know we want to move on. So if you do have questions, please come back and ask me those questions. For now, we're going to talk about the onus in dismissal cases. The onus always rests with the employer to prove that the dismissal was fair, both procedurally and substantively. Why have I taken this moment to raise this issue? It just because now you know a little bit about the audi alteram partem rule, you know a little bit about those processes for misconduct, you now know about 189, and the bottom line is that you as the employer, the onus is on you to at all times be able to prove that the dismissal was fair procedurally and substantively. So we've gone through the procedure for the misconduct. We now went through the process for 189. What are the other processes? So the next topic is then the process for capacity. And there's two kinds of capacity issues. One deals with poor work performance, and the other one deals with ill health. Now, before we discuss poor work performance, let's discuss ill health because it's a completely different process. First of all, there's no chairperson per se, it's an inquiry led by the company, where they call the employee in and they say, your back is sore. Because your back is always sore, you can't sit in the chair. Because you're a telesales marketer, if you can't sit in the chair, can you actually do this job? And then the employee can come along and say, well, it's actually the ergonomics of my back versus your crappy chair. So what I've done is I've researched and I've found a chair that will sort my back out. And here's a little pillow that I will pay for and put on this new chair. Because I am, 2.2 meters tall, I can't sit in an ordinary chair without hurting my back. That's the issue. Oh, you just need a new chair. I'll pay for the chair. Problem solved. We move on. But if it's something like you go island hopping on a Friday, you know what island hopping is? When you drive your car over the island because you're so drunk, kadunk, kadunk, and you hurt your back that way. Well, that's your fault, isn't it? If your back is now hurt and you have to take off 3 years for therapy, that's too long. I can't keep your job for 3 years. But if it's you have to take 3 days off for physio, okay, I can manage that. So did you cause the injury yourself? Is this something that is your fault? Did you willingly get COVID-19? No, you didn't. It just happened. So now you've got COVID-19, you've got to stay out of the office for 10 days. In that time, I want to, I'm going to get rid of you because I told you don't get COVID-19 and you got it. That's not your fault. That is going to be regarded as an unfair dismissal. The big issue these days, or where this topic comes in a lot, is with mental health. Now, mental health, it's one of those things people don't like admitting that they have a mental health issue. I don't know why. As soon as you admit it, then I can help you. But be that as it may, so mental health is a big hot button issue these days. So typically what happens is you don't feel well, you're depressed. You know what you need to do, but you just can't bring yourself to do it because you are depressed. I'll discuss the POPIA Act, and because there are exceptions to it, especially in a consultation process. How you're supposed to disclose the information. You don't have to disclose personal information, but you'd have to look at that context. But anyway, we're talking about ill health. So you're depressed, you stay away. The issue always comes because there's an absence from the office. And because of the absence from the office, the employer has to consider, one, how long are you going to be absent? If it's going to be too long, maybe I need to dismiss. If it's not going to be too long, then I must consider replacing you with a temp just to come and help. But now, what is your prognosis? How long is this going to take? In other words, is it a long time or a short time? Usually the long or the short of it is going to be determined by the nature of the injury. If I'm a truck driver and I lose my arm, it's going to be a permanent position that I will only have one arm. Does that mean that now I can't drive the truck? No, I can adapt the inside of the truck to cope with one arm. So that can happen. You can drive a truck with one arm. It's a bad idea, but it can happen. We've seen it. So that can happen. Then you look at the cost of those amendments to the inside of the truck. If it's going to cost you basically the cost of a new truck, you're probably going to say, I can't do it. But if it's going to cost you, 10,000 Rand, you're probably going to have to do it to accommodate them, especially if they lost their arm doing your work. If whilst they're on a truck, they're driving and there's an accident that wasn't his fault, somebody, some taxi driver drove into him, whatever, and he lost his arm, you're going to have to probably bend over backwards to try and accommodate that driver by amending the inside of the truck so he can drive with one arm. So the length of time it's going to take usually depends on the nature of the injury. Now here's where the mental health issues come in. If you come in there with a broken arm, you can see, okay, the guy's got a broken arm, his arm's in a cast, I can see it. Just because you can't see the mental injury doesn't mean that it doesn't exist. The psychologist or psychiatrist will say, these are the issues, this is the length of time it's going to take, and in that time we suggest that you put them in an alternate position, so where they're not having to face the thing that's causing them the stress. So it could be a really, really stressful situation caused by the fact that there are nasty colleagues sitting next to you that negatively comment all the time. So by taking you out of that scenario, you could very well improve your condition and you can work effectively. So it's that kind of questions that gets asked, and that is the nature of the process. It is not a question of you've got 6 weeks worth of leave, you've taken 8 weeks. Once I prove that you've taken 8 weeks, you're out. Because that is not dealing with the issue, which is what is the nature of your injury? If you had a heart attack and your recovery time from your cardiologist is 6 months, under certain circumstances, that could be sufficient time. They must keep that job open for you, especially where you're coming in after a month and, it's light duty. And after that, they can increase the amount of work that they give you. Then you can keep your job. You've worked hard for it. You're skilled, you're qualified, you understand what's going on. Why should you lose it just because you've got a dodgy heart? It's unfair. If you contract tuberculosis in the taxi on the way to work, as your employer, I'm probably going to have to try and accommodate you. But if you don't want to take the medication, probably not. It's that type of thing all the time. That's the nature of the questions that get answered. It's dealt with in item 10 and item 11 of the Code of Good Practice, which I referred you to earlier. So have a look at that. It's preceded by item 9, which deals with the failure to reach an employment standard. Now, that is the incapacity for poor work performance. So, perfect example, my secretary. When she joined, I said to her, my requirement is 200 words a minute. Okay, and we did a test, and she was the one that got the highest. She got to, let's say, 140 words per minute. But I said to her, okay, I'm going to employ you on that basis, and within 6 months, you must get to 200 words a minute. And within 6 months, she gets to 200 words a minute. And there's no problem. After 2 years, she starts slacking down, typically, want to go and smoke rather than do my typing, this, that, and the other. And she drops down to 180 words a minute. So I do the math and I say, that's not on. This is my employment standard. It's 200 words a minute. You are here, it's 180. I'm giving you 2 months to get back up to 200 and keep it there. Okay, and she bucks up and she gets to 200 words a minute and she keeps it there. And then after 6 months, she drops down to 170 words a minute. And it gets worse, 160, and now stuff isn't getting done. So now I have another discussion with her. What is the reason why you keep on dropping down and you're up and you yo-yo all the time, and you stay on a plateau and then you drop so far down? And eventually, after about 2 years of this, I will then be able to say, for failing to meet that employment standard consistently, as is my requirement, I can let you go. I can dismiss you for poor work performance over a consistent period of 2 years, despite all the efforts to try and assist you. So, what is not an employment standard? What is not an employment standard is what we call dashboard items. Something goes wrong in the engine, a light switches on the dashboard. I can certainly set what that light is. I could say your requirement is to pass 200,000 rands worth of fees a month. If you don't, the light goes off, it's a dashboard. But that doesn't mean that just because you fail to pass fees of 200,000 a month, that you have done something wrong. Your conduct might have not failed to meet that particular employment standard, but that doesn't mean that you've done something wrong. To find out what's going on, I've got to open the engine and I've got to see, You don't have enough clients. That's why you're not generating enough fees. The fact that you don't have clients is my problem. I must get you more clients. I'm going to up the marketing spend, and off we go. So, perfect example, during the worst of the financial crisis a few years back, my guy was selling trucks. And then the market fell out. Nobody was buying any trucks. Nobody was getting qualified for any interest, or loans or anything like that. What did his employer do? His employer said, you have to sell 4 trucks a month. He said, okay, I'm going to do my best. And they said, no, if you don't sell 4, then next month you must sell 8. So after 4 months, he'd only sold 2, and he owed the employer another 14. So they said to him, because you have failed to meet my employment standard, which is 4 trucks a month, you dismissed. And that was the problem, because failing to sell 4 trucks a month is a dashboard item. In the meanwhile, my advice to him was keep a diary of everything that you do. He made 60 phone calls a day. He sent 140 emails a day to various customers to see if they were interested in buying trucks. He reached out, he did everything. He was super duper. He was so diligent for 4 months, just keeping a record of everything that he had done to try and meet this dashboard requirement of 4 trucks a month. And because he couldn't meet it because the market had fallen out, we were still able to show that no, what he had done, his conduct was all spot on. And that is the issue. So with my secretary, the failure to meet the 200 words a minute, that's my employment standard. When she doesn't reach it, when she reaches it and then she falls away, then it becomes an issue. Why are you doing it? What is the conduct that, I just think you become lazy, and I can then dismiss you. But if you are not lazy, if you are making the phone calls, seeing the people, as soon as somebody steps in, you run to the front door and you say, welcome, sir. Would you like to see a truck? Is there anything I can do to help? If that's you, then you have done what you can. Your conduct is of such a nature that actually I can't do anything about it. Your performance, which is immeasurable. Can I measure your performance? Just remember, the number of trucks is just a measure of everything else that I must do to get to the point to sell the truck. So if I've kept a record of all of those things, I will win that case. I should win that case, because actually I cannot control whether somebody's going to buy the truck. All that I can do is put my best foot forward and make sure that if they are going to buy the truck, they're going to buy the truck from me. But if there's no market for trucks, it's not my fault. If you've got a requirement of 200,000 Rand a month in fees and you don't have any clients because of COVID-19, you can't run criminal trials or whatever the story is, have you done anything wrong? No, you've read all the cases, you've kept things going, you've kept up to date with all your legislation, and that type of thing. There's a question here around POPIA. So this is obviously the Protection of Personal Information Act. Typically, you wouldn't find that in an employment context because everyone knows who you are. How much do you earn? Well, that could be confidential, so I can't just disclose that willy-nilly. But that doesn't mean that I can't, at a very general level, disclose the fact that you are employed here and that you earn in this sort of range. I can give a salary band between 400 and 500,000 Rand a month. That's information. The POPIA Act is obviously, it's got its own set of legislation that protects the personal information, especially of third parties. But it won't necessarily be intersay with the employer and employee. So you'd have to have a look at the Act and see whether or not those exceptions apply. And if they do apply, well, then you've got to apply those exceptions. If not, then you've got to try and comply. The progressive disciplinary action, it's usually in the case of misconduct. So this has got nothing to do with capacity or incapacity, and there's 2 kinds of incapacity, one we discussed now, which was the poor work performance, and the other one was the ill health. What we're talking about, progressive application of discipline, is usually in a misconduct setting, and it's, you come late. I can't just dismiss you for coming late. I've got to give you warnings because the issuing dispute it's not something that warrants dismissal, but there are cases where dismissal is warranted, especially things relating to honesty or dishonesty. So if you steal something, yes, I can dismiss you and I don't have to give you a warning. But if you come late, typically I could give you a warning. I could even give you 2 or 3 warnings before I dismiss you. But eventually they all militate, they all add up, and you get to the point where you can dismiss. So I hope that answers that question. I do see that it's 1:05. If you have any questions, please use the break to try and just deal with that. And you can hopefully post those questions. We can get done. So when we come back, we are going to be talking about residual unfair labor practices and constructive dismissal disputes. But up until then, please enjoy your lunch. We'll come back can we come back at 1:45, just so that we can try and get done a little bit earlier. We should be done by 2:30. I'll certainly move heaven and earth on my side to try and get it done by 2:30, 2:45 for the latest. And if you do have any questions, you're welcome to put them up. Okay, thank you. I'll see you at 2:45. I'm going to leave everything on again just so that we can keep it going. Okay, thanks.
Yo. Kuhle unjani? Hayi singane. Ufuna ikopi yazo? Eyiphi charge? Or the first offense? Okay, konsendele email yakho ku-WhatsApp. Okay, sure.
Tamsanga, Mr. Tsawe, your mic is not on mute.
Whoa. Oh, sorry. Yo.
Okay. It's just about 1:45. Should we crack on?
Yes, I'm here.
Okay, great. So one of the things I'm required to do is to run a case study with you. So these are from actual facts of actual matter. So let's just run through them quickly, shall we? ULabs employ approximately 15 persons, of which 12 are permanent and 3 are casuals. The casuals work for between 10 and 197 hours per month for ULabs. They get paid a set hourly rate and daily employment is not guaranteed. As and when they are needed, the manager of ULabs calls those persons in to do general work around the lab. ULabs then merge with another lab and move their premises. It was from Somerset West to Durbanville. Prior to concluding the move, the manager calls in the 3 casual employees and advises them that in a month or so there will be no more work for them as the company is closing down and moving. He reminds them the following month, and at the end of the month advises them that they have now come to the end of their term with their employer, and because they are casual, that is the end of the matter. The employer is to decide to refer a dispute to the CCMA claiming unfair dismissal. What advice, if any, would you have acting for the employer, and what advice would you have for the employees? So again, the starting point is, well, can anyone advise the view, where do you start in this matter? What is the starting point? The starting point is, of course, are you an employee? What happens if you are an employee? Well, then you are entitled to the protections of the Act. So in this case, even though they were casuals, they were employees. And because they were employees, well, that means that they had to be consulted properly in terms of Section 189. So I can scroll up. That's the starting point. Because once you're an employee, then you are entitled to all the protections in the Act. Not so, which includes the right to be consulted around a change in the operational requirements of the business. So acting for the employer, what's your advice? You know, if you can't win, then you must fold. So we folded and we settled with them, and that was that. So just to demonstrate the fact that it doesn't matter if you're in irregular employment. If you are an employee, then you are an employee. The CCMA has gone so far as to say, if somebody's a casual and they're looking for permanent employment, that's a promotion dispute. If somebody's in a pool of casual employees and you want to no longer draw from that, they have to be consulted. So there's all kinds of things in there, and it's not just a summa sudum, as they say. The next case study is Porter Motors versus, or Karachi versus Porter Motors. We'll just run through the facts very briefly, and then hopefully we can have a very quick discussion. So Miss Karachi was working for Porter Motors. She'd been there for almost 9 years. So this is the motor industry. She was working at the Cavendish branch of Porter Motors. Can you believe it? Anyway, Porter Motors decided to close that particular branch, and Miss Karachi goes into what we call a pool of displaced employees. So where the branch gets closed and there's 2 or 3 branches that gets closed, everyone gets placed in this pool. From the pool, in terms of the rules that applied at the time, there was an opportunity to bump another employee out. So bumping, what does bumping mean? Yeah, well, there you go. There's the answer. There should have been consultation, and there should have been some discussion around the consultation topics, including severance pay. But bumping from the pool of displaced employees, as somebody with longer service. So let's say I've got 9 years service, so I get placed somewhere here at the top of the list. And somebody who's got similar service and they do something similar to what I do, I can bump them out. So they've got 7 years. This person then can bump somebody out with 6 years and 5 and 4 and go all the way down to the bottom until the last employee who just joined the other day, even though their jobs are safe, they can then get bumped out. That way you retain the staff. Yeah, so you get to bump somebody out with lesser experience. Quite right. And that is exactly what happened with Ms. Karachi. So she goes into the pool and a range of possibilities exists for Ms. Karachi. A list of employees is presented to her, all of whom have lesser service than her. The only position with which she feels comfortable are positions attached to the Noordhoek dealership and another one in the retreat area. So the Noordhoek position is what she wants because the salary is more or less on par. However, she lives in Athlone. To travel to Noordhoek is a bit much. The retreat position is acceptable as it is identical to the position she occupied previously. However, the salary is much less. So this was in the early sort of late 1990s. So we're not talking about a lot of money. We're talking about sort of an 800 Rand difference between the two positions. So she chooses retreat, but the Noordhoek salary. And as you can imagine, management is not too enamored with this. They reject that process or that suggestion. They complete the consultations and eventually she's retrenched. So the question is now, she refers a dispute. What's your advice to the employer? Here's an issue here. My husband was also in the motor industry, was afforded the option. However, we knew the other person had a wife. And so if you choose not to bump, of course, then that's up to you. The fact that you have a solution doesn't mean that you have to follow it. It is up to you. But what you then can't do is you can't contest the fairness of that dismissal because in essence, you've waived your rights. So I'm assuming that, like me, everyone wants to litigate all the time about every single thing. Not necessarily, I'm just joking, but it really is up to you. But in this scenario, in this example, in this actual case study, what would be the advice to the employer? So by the time I got hold of the matter, she'd already been retrenched. So remember, and this is to emphasize the fact that with the retrenchments, the issue in dispute is what you need to consult about. Now, what is the issue in dispute here? The issue in dispute here is Noordhoek salary, retreat position. What is it about? It's about the money. So did you, and that was the first question I asked my client, did you consult with her about the money? Did you say, look, I can't do the Noordhoek salary in the retreat position because it's a small branch, I can't afford it, but can you, instead of taking 800, take 600 or 400 or 200 extra? That could have notionally solved the problem, and because that was a viable alternative to dismissal, the Labour Court obviously very quickly, the judge sussed it out and then said, no. If you didn't consult about the salary levels, not that you had to agree to the 800, you just had to consult about it. And because you didn't consult, it was ruled an unfair dismissal. So that's just an example. So I want you, if we were face to face, what we would have done is I'd have put the 711 referral form up on the screen and we'd have completed it together using these facts, just to show you how simple and easy it is to complete. But if you're invited to use these facts and to try and complete the 711 referral form so that you can discover for yourself how simple and easy it is to actually get these processes done. Are there any questions before I move off on this? Because I'm going to go back to the collective labor law side of things. If you are ready for that, we can move swiftly along. Otherwise, please post your questions. That having been said and done, we are going to move swiftly along. Just have to go back to where we were. Sorry. Ah, here we are. So here the focus, where we left off, we were discussing a little bit about the procedure, and in the residual unfair labor practice disputes and constructive dismissal disputes, it is the normal onus. So normal onus is the person who makes the allegations must prove the allegations. So if you say you were unfairly demoted or promoted, or somebody else was advantaged at your expense and it was unfair, then you've got to prove those things. If you fail to prove it, you lose the case. It's very simple. But where it comes to an unfair dismissal claim and the like, the onus reverses, and the onus is on the employer to prove that the dismissal was fair both procedurally and substantively. So that's the last time we're going to be discussing onus in these disputes. So if you do have any questions, you're welcome to put it up. Collective and labor law, it's basically strikes and lockouts. So what is a strike? What is a lockout? Is a go slow a strike? What is a go slow? So a go slow is you're supposed to do, I don't know, 50 t-shirts an hour, and you decide to go slow as a form of protest, and you say that, I'm only doing 20. So that go slow is a form of protest, and because it's a form of protest, it is a strike. Strike law applies. The same with overtime bans. Those of you who practice in the area of criminal law will know that the courts run and operate because the prosecutors arrive there at 7 o'clock, start interviewing witness, get their day done, all of those things. So when they're terribly unhappy, they arrive at 9 o'clock like they're supposed to. And then you try and get a court going, from there. You'll maybe get one case done, one postponement, and then they take their tea break and they just work to rule. And when they work to rule, nothing gets done. They refuse to do any overtime. It's an overtime ban. All of these are forms of protest, and they're all regulated in the same way as a strike is regulated. So it's important to understand that. A lockout is the employer response to a strike. Now you could go so far as to lock out. I could lock you out because I want you to start at 8 o'clock and not at 9 o'clock. In other words, I want to force you to change your terms and conditions of employment. That's what you call an offensive lockout, as opposed to a defensive lockout, which we will discuss the differences because they have different consequences. But notionally that's available. So a strike, an employee's right to go on strike. One employee can never go on strike. It has to be more than one. The employer equivalent power is the lockout. Now, if you look at Chapter 4 of the Labour Relations Act, which is basically Section 64 through to 77, the most important thing is around the process. There are two kinds of processes that follow: disputes of right and disputes of interest. What is a dispute of right? Well, a dispute of right is where you have a dispute and there's a right that attaches to it. If there's a right that attaches to it, well, then you should be able to resolve that dispute by going to some sort of dispute resolution forum. If you have a lease agreement that says you got a lease until 2023 and they now want to kick you out to get another tenant in there, you would go and you'd take your lease agreement and you'd enforce that right in terms of whatever court processes are available to you. So that's a dispute of right. But if I want to, for example, you have the right to earn 20 Rand an hour, and I instead want to use, you know, I want to drop your salary to 15 Rand per hour, then I've got to exercise my power to try and get you there. First of all, I've got to declare a dispute. I'm doing this in reverse in the sense of usually it's employees coming along wanting to earn more. But just to try and drive home the point that it is equal and opposite, as an employer, I want to pay you 15, from 20 down to 15. So you've got a right there to earn 20, so I can't just act unilaterally, or else you're going to enforce those rights against me. But as your employer, I've got an interest in trying to force you down to 15. So what must I do? I must then refer that matter to the Bargaining Council or the CCMA. During that time, for a period of 30 days, they will try and resolve that dispute. They'll have consultations. They'll say, Mr. Employer, you're crazy. Why 20 down to 15? You know, if we don't do it, what's going to happen? All of those good things. So they try and consult and cajole and do whatever they can to get that dispute resolved. If there's no dispute that is capable of being resolved, then you get a certificate, and that certificate gives you the right on 48 hours notice in writing if you're an employee to go on strike, if you're an employer to go on a lockout. And at a very general level, that's the process. Very simple. Now you're going to say, well, what changed? Not a lot. Just that we forced that 30 days consultation, a cooling off period. And during that time, hopefully, the parties can and they can of lockout. Then you know, that's when things get really heated. Even the legitimate has turned very violent. When he took on the two different trade unions, one largely had 60 odd people got stabbed on trains. It was crazy. His question, can an attorney have client work on any acts during negotiations and employees pays him or her a monthly subscription? So, I mean, of course, an attorney can have clients anyway. It's what is he doing in the negotiations? He should be excluded. So that's an issue because it's, you know, the parties themselves must do the negotiation. But you can have a situation where
For the last 4 or 5 minutes, the sound's been very, very bad, distorted. I don't think many of us heard much of what was said. If you don't mind just repeating from lockout.
I have literally just not changed anything on any of my settings, but I'll go over it again. So you want us to pick it up from about here with a 48 hours notice in writing. So the process is just to run through it again. If it's a dispute where there is a right attached to it, then generally you would have to go and enforce those rights. If it's a dispute of interest, then I've got to take that dispute, properly describe it, send it to the CCMA. I think it's a 7/7 referral form, but don't quote me on that. You can go and check it out yourselves. For 30 days, then at the CCMA, they'll try and get that dispute settled. And if there's no settlement, you get a certificate that allows you to go out on strike, or if you're an employer, to go out and implement a lockout. Once you implement the lockout, there's different consequences that flow. Did everybody get that? I'm hoping it's something on your side and not my side, because if it is on my side, I don't know what I'd do. But yeah, I say, yeah, Yasmin saying the sound is very bad, that you can't hear. I don't know what else I can do to try and increase that.
The sound is better now, so I think if you just continue from there, if it's possible.
Okay, no worries. I shall do so. So an offensive lockout is where an employer, in support of his or her demand, locks out the employees. When you do an offensive lockout such as that, that's called an offensive lockout, I'm attacking you, it's offensive, then I cannot hire any replacement labor or scabs. If, however, it's you that go on strike in support of your demand for a higher wage, then I can lock you out. In other words, you can't come back in until you accept my offer, and that's called a defensive lockout. And with a defensive lockout, the difference is that I can then hire scab labor, temporary labor. I can go to labor brokers and say, I want your people to come and work for me for as long as we have a strike. High unemployment rates in South Africa, you can see how people will agree to that. That having been said, that's the difference between an offensive lockout and a defensive lockout. Now, just to tie everything nicely together for you, I'm going to tell you about the following true story. And it starts with, when is a strike over? Obviously, a strike is over by agreement between the parties. I want 12%, you want 2%, and somewhere in the middle we agree on 6%. We agree, and once the demands are met, there's an agreement, and that's the end of the strike. But when all else fails, you can go look at that case of Sakwu versus Afrox. And it touches on so many different things. I thought, let me just tell you the story. So what happened was that Afrox, they deliver gas via their tankers to the various hospitals, and wherever you need gas, they will just deliver. And what had happened, they had what they called structured overtime. Everyone worked 12-hour shifts for 5 days a week. So 5 times 12 is 60, no problem. Along came the amendments to the Basic Conditions of Employment Act, where they tried to move from the 48 hours to 45, with a plan to move to 40. So the very first change was 48 to 45 hours per week. They dropped the number of hours. And when you do 45 plus 12, which is the amount of overtime you can work, you get to 57. So Afrox was coming 3 hours short. So they had a look at it and they said, no, that's not going to work. Our customers are hospitals and the like. We need to cover that basis. So we are going to implement what they call continental shifts for all their drivers. So they work 8-8-8. So we work for 8 hours. They have a morning shift, an afternoon shift, and a night shift, and everyone just works 8 hours. When you do that 8 times 5 days a week, you get to 40 hours, not to 60 hours. So that was the problem. The problem was that with the structured overtime, the drivers were being paid double time for overtime. So even though they only worked 12 hours, they were getting paid 24 hours. When you add that 24 to your 48, you get to 72. And now all of a sudden they're being asked to only earn 40 hours. Immediately they went on a wildcat strike because they were terribly upset. Immediately Afrox applied for an interdict to stop the wildcat strike and also implemented a defensive lockout. Because nobody had actually declared any disputes, when the defensive lockout took hold, Sakwu then went off to the Labour Court to try and set that aside, and it was set aside. But during that time when the defensive lockout was in place, Afrox did something very clever. What they did was they went to a company called Drivers Galore, which is a temporary employment service. They just employ drivers. And Drivers Galore came with their clipboards and their salespeople, and they had a look at it and they said, look, Afrox, The problem is that your drivers, you actually need 2 drivers in the cab, and that way we can then run 16-hour shifts and do it like this and do it like that. And super duper, here's your quote. And Afrox had a look at the quote, and even at the 8-hour shifts, it was much cheaper. So you could just see them working it out in their head. Click, click, click. Why don't we just outsource the entire bloody service? So they made that decision. So they immediately went to the trade union and said, look, we're no longer implementing this 8-hour shifts. Come back to work. Everybody came back to work. As they came in, they got their section 189 letters where they're contemplating retrenchment, outsourcing the service to drivers galore, immediate wildcat strike, immediate interdict, defensive lockouts, the whole work. And they ended up retrenching all the drivers. Now, when you look at those Afrox trucks, you have a look and you'll see there's 2 drivers, none of whom are employed by Afrox. They're all working for a temporary employment service called Drivers Galore. How they managed to do it in the face of section 198 capital A, I don't know, I haven't inquired into it. But they, in one foul swoop, managed to get rid of all the drivers, and in one foul swoop managed to restructure their business, and in one foul swoop also managed to outsource. So that's what happened in that case. It's got everything in it. If you want to just find out, you know, how do you get to a position where the strike is over, go and read that case. It is terribly interesting. It is an old case, but it is a classic, an oldie but a goodie. I went all the way to the LAC, as they say. Moving on from there, Labour Court jurisdiction. What do you need to know about the Labour Court? Just like the High Court, it has inherent jurisdiction. What does that mean? That every single dispute concerning a contract of employment, concerning a labour matter, excuse me, the Labour Court has inherent and supposed to be exclusive jurisdiction over it. But as you know, you can't have inherent jurisdiction in the High Court and then exclude certain things. So even the High Court will say, no, 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 we've got jurisdiction over unfair dismissal disputes even. They can't apply the Labour Relations Act because in the Labour Relations Act, it says specifically that only the Labour Court can use the Labour Relations Act to adjudicate disputes. So even though they excluded from using the Labour Relations Act, doesn't mean they can't venture into there. They use their common law jurisdiction. And there was a case very recently, Archer versus Pinelands High School. For those of you who went to Pinelands High School, it was a very interesting dispute. Mr. Archer was employed, or somebody's put their mic on. Can we just double check because it is coming through. I'm sure everybody can hear that. But Mr. Archer, or Miss Archer, I think it was Mr. He was employed by the SGB, but he fell out with the principal and the principal disciplined him and fired him. And his position was, well, the wrong party fired me and disciplined me. It should have been the SGB, not the principal. Craig Bosch took.
So you've muted your mic.
Yeah, so where did you miss from Archer versus the SGB?
Yeah.
Okay, so I don't know what happened there. It just does its own thing sometimes. But Archer's defense to the dismissal claim, in essence, was that the wrong party had disciplined him and dismissed him. It should have been the SGB. Craig Bosch, acting for Mr. Archer or Miss Archer, took that point, and it was confirmed at the Labour Court that the common law claim can also now go ahead in the Labour Court and can be entertained in addition to the unfair dismissal claim. So that's new law that's coming through. We'll see there. I mean, imagine every single unfair dismissal claim, you can also pursue a common law claim, which would be make life pretty interesting but we'll see how that develops. So labour matters, inherent jurisdiction, labour court. It also has an equity jurisdiction. So just like the CCMA can ask the question, well, is it fair? The labour court can also ask that question. But now the thing is that let's say it's a contractual claim. It's a restraint of trade claim. Is it fair to the labour court, for the labour court to ask the question, is this restraint fair? They can certainly ask the question, but it's going to be determined on the normal rules around restraint of trade. It's not going, you won't be able to just exercise equity jurisdiction over normal contractual disputes. The equity jurisdiction is reserved for the unfair dismissal claims and things related to that, the residual unfair labour practice, constructive dismissal, retrenchments, that sort of thing. It's not meant for the restraint of trade or the normal contractual disputes, that type of thing. So they're still going to rely on the common law, and they're still going to rely on those normal contractual principles. So just because you've got a overtime claim doesn't mean that the labour court is now suddenly going to enter into this using its equity jurisdiction. Same with employment equity. The labour court is the court of last resort when it concerns employment equity. Obviously, they can take it all the way up to the Con Court, but you can't take an employment equity dispute to the High Court, even though they have inherent jurisdiction. They exclude it from the legislation, so it's a bit hard. And there's lots of interesting cases, and I'll tell you about two of them now very shortly, just dealing with employment equity disputes and how those get resolved. Automatically unfair dismissals, they go to the labour court exclusively. Retrenchments involving more than one employee, they go to the labour court exclusively. So especially the large scale retrenchments. Oh, that was way too fast. Those go to the labour court exclusively. Then there's, of course, there's the reviews, which I did promise you at the beginning that we'd have a look at. But let's just talk very briefly about employment equity disputes. And this is the place where the rubber meets the road for you a lot of the time. A lot of you are going to have to face these issues in your workplace. Who knows how it's going to come about, but once it gets there, this is more or less the lay of the land. So as you know, with our history of apartheid and the need for, let's call it affirmative action. I need to affirm you because you are black, you are female, you are male, whatever, doesn't matter, but you've got a severe disadvantage in the sense that, you know, you didn't go to the best schools, you just came through the education system. There wasn't a leg up given to you, whereas for a lot of our white colleagues, there was a leg given up and an advantage and an inside lane was given. So now Mandela's release is 94. There's a need for affirmative action. Mandela calls all the large employers into a room. More than 300 of them, talks about the need for employment equity and affirmative action. They all put up their hands and say, look, just give us a chance. Give us a chance, give us 2-3 years, let us show you what we do. And in that time, it was the time of the BE deals. Tokyo, Sequale, and all of these big boys got given shares, and you know they could pay it back with the dividends they were going to earn on the shares. And a lot of people made a lot of money, but it wasn't broad-based. It was employment. It was certainly affirmative action in one way or another, but there was maybe 1,000 people that benefited. Mandela said, no, that's not going to work. And the Employment Equity Act was born. And what it requires is it requires of employers to take stock of everything that takes place in their workplace. They've got to have a look at what are your policies. So let's say you have drinks on a Friday you know, if you're just going to have Chardonnay, you're probably not going to get a lot of people who don't drink Chardonnay coming to your functions. So that's not a very inclusive thing. So you could stick something like that into an employment equity plan, but you know, that's not really the issue. The issue is around the hiring practices. So most firms these days will seek to advance their employment equity goals by hiring, for example, only black females until such time as our staff in our firm looks and reflects more what the South African population is like. So that's a goal, an employment equity goal, and it translates into a practice, and so we go on. So part of the process is identifying barriers to advancement. It could be that you are only hiring people from Rondebosch Boys High, in which case you're never going to get females coming from Rondebosch Boys High, and you're probably going to get a certain hue or color of applicant. So that's not going to take you very far. So that's an employment barrier, a barrier to advancement. Once I identify what those barriers are, I then got to decide on how am I going to get over those barriers. Moving on from there, I've then got to put all of that in an employment equity plan. And once I've got that plan going, then people can judge me on that. I've got to file that plan. And every year I've got to advance the goals and say why I didn't make it, all of those things. But now what happens if you are a black female and you believe that you should be advanced? In other words, the employer is not doing enough to affirm you. And this was the case with Lillian Dudley. Lillian Dudley worked for the Cape Metropolitan Council. It supplied bulk services to 6 municipalities or MLCs, Metropolitan Local Councils, including the City of Cape Town. The City of Cape Town, in the health services, they had Dr. Ivor Toms. You can go and research him. He was one of the first recipients of a civil order called the Mapungubwe Order of the Mapungubwe for his services in fighting apartheid. He was a conscientious objector. He was a doctor, and instead of going to the army, he went to the City of Cape Town, and he said, I don't want to fight, and I'm a pacifist. Let me do your health services for you. And he was a genius. He invented things like the family planning clinic, invented the HIV clinic, invented all of these primary healthcare institutions. And he was so good, very soon he had about 3,000 people reporting to him. And all the other MLCs came to the City of Cape Town and said, you guys are doing it so well, don't you just want to roll it out on our behalf so we don't have to reinvent the wheel? We'll just pay you an agency basis. So there was Ivor Toms, and he was in head of these 3,000 odd staff dotted all over the Western Cape delivering primary healthcare services. And then they decided to create the Unicity. When they created the Unicity, Lillian Dudley then applied for that post. And she didn't get it, but she was appointed in there on a temporary basis in an acting position, and he now had to report to her. But when the post came to be filled permanently, the City of Cape Town said, well, we want somebody who can score 90% in this function. He was white, remember, and she's black, and she's a female. And they said, because if we get it wrong, then people will die. So that was their standard, and they applied that standard, and they appointed him. She declared a dispute, and her dispute was that the City of Cape Town has not done enough to affirm me as a black female. And she took that all the way to the Labour Appeal Court, and the Labour Appeal Court said, look, if there's a dispute about whether or not the affirmative action measures goes not far enough or it should go further, that is a dispute that you must take to the Department of Labour. You can't bring it to court. You compare that to another case that happened, which was it was Lillian Dudley and Charles, which we'll get to now. But he also, Harmse, Charlie Harmse, that was his dispute, yeah. So what happened with Charlie Harmse, similar thing, but just that he applied for about 6 or 7 positions. He couldn't really pick on one, but the Labour Court gave him that go-ahead to take his dispute through on the basis that not enough affirmative action measures had been taken to advance him. He lost in the Labour Court and he lost in the Labour Appeal Court. So the position now is, if you've got an issue around it, it's got to take it to the Department of Labour. And they will send inspectors and deal with the matter on that level. There won't necessarily be a right of action arising from it. So that's how the Employment Equity Act finds its way into our labour court. There won't be too many disputes around that. Of course, the labour court, one of their biggest functions is, of course, the review function. So it does say their labour court jurisdiction continued. That's because my secretary had organised the slides in a very crazy way, where those slides right at the beginning should have been in that space there. Sorry, there's somebody else on the line as well. Anyway, so we start off life with Carphone versus Marcus. In the Carphone versus Marcus case, which was now what is the standard for reviews in the Labour Court? And the Labour Court came up with a test in Carphone versus Marcus, which said that we have a look at the material that was placed in front of the arbitrator, and we then decide whether or not that material is in keeping with the decision that was made by the decision maker. In other words, the conclusion is not rational or justified in relation to the material that was placed before the decision maker. But if you sit back and you think about it, doesn't that just sound like an appeal? It does, eh? You had a look at what did we place before you. We showed you all the evidence that there was only water consumed, and you came to the conclusion that there was alcohol consumed. Nobody said there was any alcohol. How could you come to the decision? The decision is not rational or justified in relation to the material placed before you. So for many years, that was then the law. And along came Rustenburg Platinum Mines. You've got to love Rustenburg Platinum Mines. This is in fact where the Marikana dispute took place, where they, instead of going the labour route, they in addition took a turn at the SCA. And at the SCA, they said the decision, the focus is not on justifiability, in other words, can you justify the decision, but rather the process and the way the decision was made. So what was going on here? So to tell you, for you to understand the review jurisdiction of the Labour Court currently, you've got to understand what happened in this case of Sudumo versus Rustenburg Platinum Mine. So Mr. Sudumo was a security guard, and he worked the perimeter fence, and he was super duper. And for about 4 or 5 years, he did perimeter, and they said, oh, this guy's super duper. We're going to bring him into the high value center. The high value center is where they turn the actual ore or the material that they extract from the ground into a brick of platinum. So the ratio was sort of, 2 tons, you get 1 brick. And then Mr. Sudumo started security, and they noticed actually it's now 3 tons, 1 brick. Something's going on, so they called in the geologist, and the geologist confirmed, no, it should be 2:1, not 3:1. The material is very ore rich, and they didn't understand it, so they called in a consultant. The first thing he did is he looked at all the security tapes, and he noticed that Mr. Sudumo, instead of patting down everyone, was patting down every sort of 3rd, 4th person. So if you're working in the high value center, you can find a nice little nugget, and you can make sure that you're the 2nd or the 3rd person, and you can smuggle that out. And that was happening. Literally, the ore was leaving through the front door. So they called Mr. Sudumo in, and they showed him all of these, and he said, oh, okay, that's a problem. I understand. I will start patting down everyone. And Rustenburg Platinum Mine said, no, no, no. You owe us $4 million US. That's how much money we lost in the time that you decided not to pat down everyone. So they fired him, and he took that to the CCMA. And now we were up against all that legislation that said, got to have deference to the employer, if the employer makes a decision and it falls within what we call the band of reasonableness, you can't really disturb that employer. The review, all of those things were there. Of course, Mr. Sudumo, who was represented by Kasatu Trade Union, they said, no, that's all rubbish. And they addressed the commissioner on how he should approach the matter. And he said, the employer's sanction is but one of the factors. There should be no deference to the employer. The view of the employer is just one of the factors. There's no such thing as a reasonable employer test. A reasonable employer test is rather in this band of reasonableness. If I, as an employer, make a decision and it falls within this band, then you can't really disturb my decision. So you could be here and you could be here and you could be at different positions, but as long as it's in this band of reasonableness, deference must be given, can't disturb. Commissioner said, no, that's rubbish, agreed with the Kasatu unions and set the dismissal aside on the basis that they didn't really train him. So they then took that to the LAC, where they lost. They took it to the SCA, which is the decision we dealt with, and eventually it made it to the Constitutional Court. So in the Constitutional Court, that is what the Constitutional Court had to say. There's no reasonable employer test any longer in South African law. No deference is given to the employer. Rather, the employer sanction is just part of the factors that must be assessed. I've dealt with Carefone before. Now, if it falls within the commissioner's discretion as to what the outcome is, then now the test is the decision one that a reasonable decision maker could reach. So instead of a reasonable employer test, we've now got, in essence, what is referred to as a reasonable arbitrator test. And what that means is that if it's within his discretion to make a decision one way or another, and as long as the commissioner, he or she applies his mind to the question, then you can't really upset that on review. So that's the test as it currently stands. And that's a lot of what I do is reviews, whereas before, when it was more an appeal, of course it was a little bit easier, but now with this reasonable commissioner or reasonable arbitrator test, it is not so easy. It is in fact very hard to succeed with a review, but you know, some employers nevertheless want to take it on, so you know, who am I to say no? So we take it on, and 9 times out of 10 we will end up losing. Retrenchments in the Labour Court. I don't know if I need to deal with this extensively. We've been through the processes, and we have dealt with it. It's here because it's I won't say it's an important section, but it's for your understanding, it's an important section. I won't necessarily say it's going to end up in the exam question paper. Urgence. Basically the same requirements for urgence as you've grown up being used to, especially with High Court urgent applications. You know, is there harm, irreparable, anticipated? Are there alternatives? Balance of convenience? All of those things comes into it. You meet those requirements, you will get your interdict. It's usually to interdict a strike or a lockout. When do you interdict a lockout? So I told you about the defensive lockouts, and you can then hire a scab. But what if I go on strike and I say I'm going on a 24-hour strike, and at the end of the 24 hours you still want to lock me out? Well, then I go to court and I get to interdict you from implementing your lockout. Because I said I'm only going on strike for 24 hours. Next week I'll go on 48 hours. The week after I'll go for 72 hours, and I can do that. I can, instead of just going on a long strike, I can just decide to do it sort of piecemeal because it's more disruptive. So that's the advice that we give our trade union clients, and it does tend to work. What do you need to know about labour court practice? So attorneys are allowed, but candidate attorneys unfortunately not. So you can appear in the CCMA but not in the labour court. Why? Because you need to be admitted to practice. It is a superior court. So what do I have to do? I have to wear a dark suit, a sober tie and a white shirt. Then the Law Society decided that actually my sober tie must be replaced by a bib, because somehow I appeared to be less of a person when I was wearing a tie and the advocates was wearing a bib. So now I've got to wear a bib as well. I've got to wear my gown. And in the beginning it used to be judge. Now it's my lord, my lady. Judge Zondo was the second judge president of the Labour Court, and he changed it from judge this to judge that to my lord and my lady. He insisted on the formality. He's now a constitutional court judge and deputy president of deputy judge president of South Africa. So we will defer to him, and we will call them my lords and my lady, and we will wear our gowns and our bibs. Any questions so far? I am trying to get to the end of things. But that doesn't mean you shouldn't ask questions. If you have any, you're welcome to do so. Just returning to the non-litigious side of things now. I do lots of contracts of employment, disciplinary codes, collective agreement. I've just done a bargaining council exemption application. So this is where the bargaining council, there was a multi-year agreement on increases, 7%, 6%, and then 5%. And what we then did now, obviously with COVID-19, we got no money to pay the 5%. So we go on and we asked them to please exempt us from that. You got to meet their requirements, financial information, serve the application on the staff, and then they will determine it. Pension fund law, there's lots of law in the pension fund space. There's in fact a pension fund lawyers association. Immigration law, this is also an aspect of labor law or employment law. I give lots of UIF advice. We had a staff member here who at the ripe old age of 86 decided to retire, and she asked, can she get UIF? I said, I don't think so, but let's put in the application. Put in the application, and somebody there must have thought, my God, this woman is still alive. We're going to give her some money. Because when you retire, you shouldn't really get benefits on both sides from the UIF and from your retirement plans. Lots of workplace interventions. What are these? People fall out with each other. They hate each other. They stab each other's tires, or do crazy things. So they parachute me in, and I come and I listen to everyone and I try and sort out. And then we end up saying, well, you do this, you do that, and as long as you do this, you'd stay from doing that, and lay down the laws. And if you break my laws, then the employer will look at you with a different lens, and it could be a misconduct lens because now there are rules. I sit on lots of recruitment and selection panels. Why am I there? Well, to make sure that employers don't ask those questions around, for example, your plans for the future from a child rearing point of view, procreation, that sort of stuff. I'm both the employment equity officer and the skills development officer for our firm. What that means in essence is that I do the facilitation with the staff, where we decide what are our needs as a business, where do we need to train. We've taken an accountant and turned them into a paralegal. We've taken a paralegal, turned it into an accountant. We've sent them for the training. It was all part of our skills development plan. That way we didn't have to hire from outside. We kept it in. We've got a skills development plan which talks to our employment equity plan and how to move those things along. So that's some of the stuff that we end up doing. A lot of what we do, and unfortunately I don't have these slides here, but if you email me, I will send you Section 29 of the Basic Conditions of Employment Act, where you end up drafting employment contracts. So in the past, a section or a question or two has come from the drafting of employment contracts. where you are using just the basics now. So the basic conditions of Employment Act. In other words, there's nothing major that you have to deal with. It's not like you're dealing with a race car driver and, you know, whether or not he wins or not and how he gets paid and everything else. Nothing major. It's just a very basic contract. So Section 29 deals with those things. It tells you what it is that you need to address. So nothing earth-shattering. It's basic things like you've got to have your name as the employer and where you are, your place of employment, because that's where I must go and work. I must tender my services at number 80 Mackenzie Street, for example. So it's Harold Gee Attorneys, 80 Mackenzie Street on one part, and Charlie Philander, or Charlotte Philander, sorry, on the other part with maybe an ID number, their contact number, their next of kin, maybe their address. So very basic information. Then I need to tell you about what it is that you need to do. So again, it's a bad idea to give a lot of detail. Because if I say you are a receptionist and you answer the Spock telephone, and I change the Spock telephone from Spock to Siemens, and you can say, oh, my position's redundant, you need to retrench me, and I might not want to retrench you, I might want to keep you. So I don't put that level of detail. I will say things like you are a front office assistant and part of your duties is answering phones, welcoming guests, doing da-da-da, and I just add on and I add on and I add on and I describe it very generally. That way, you know, when I need to change things, as long as it falls within there, it should be fine. If I appoint you as a front office assistant and I then want to make you, I don't know, clean cars, you can say that doesn't fall within my job description. You can say that, but at the end of the day, I can nevertheless make you clean those cars. It's quite demeaning, and I could end up with a constructive dismissal claim, but that doesn't mean that I can't ask you to do it. So again, it's Section 29, and there's a lot of detail in there, and I'd encourage you to read it, especially for the exam, and it should be in your notes as well. But moving on from there, if there's a sectoral determination that regulates your employment, I must tell you about it. So if you're a security guard, I should say your employment terms and conditions are regulated by sectoral determination number 6, or the main collective agreement in the bargaining council, and then I've got to tell you more or less where you can get copies of it. In my business, I've got to make copies and stick it on a notice board so that people can go and read up about it. So sectoral determinations, wage determinations, collective agreements that regulate terms and conditions of employment, I've got to put it in there and say where you can get copies of it. So it's normally on the HR notice board downstairs, in the basement, the second basement, to the left of the right basement, you know. So eventually it's stuck down at the bottom over there. But most people, they just stick up those those posters. You get the Basic Conditions of Employment Act, the Labour Relations Act, and anything else. You can just get a poster, stick it up on the notice board, move on from there. I've got to tell you how often you get paid, and you've got to get paid in rand. So I can pay you daily, weekly, monthly, and that's about it. I can't pay you once a quarter because how are you going to survive until then? It doesn't make a lot of sense. So the restraints of trade, and I'll take you through some of those things, still enforceable in today's times. Confidentiality undertakings, if you email me, I'll send you a confidentiality undertakings. Information about your remuneration, what forms part of it, what doesn't. There's a code of good practice on the definition of remuneration if there's ever a dispute. And there's also a very detailed section, I think it's section 38, which just deals with how you calculate remuneration. Not all remuneration is calculated with reference to time. It could be calculated with reference to, example, piecemeal work. You get paid 50 cents per t-shirt or 100 rand per job lot that you complete, and that's how you continue. Think of commission earners only, where they only earn commission. Think about also a combination of commission and hourly base. So you get paid 10 Rand an hour and then 15% on all the meals that you sell. You know, it's a combination, so you can deal with all of those things, and it's not a problem for you to stick it into your employment contracts. It just really depends. I see there's some questions. Okay, in kind remuneration, what qualifies for this type of remuneration? So remuneration in kind doesn't really exist, because how are you going to take that kind and turn it into, I don't know, shoes for your children or food? So what does tend to happen is, let's say I let you stay on my premises. So you work for me, you're a domestic worker, I pay you 100 Rand per hour, and you get to live on the premises. So that's remuneration in kind, or there's some sort of support that's given to you where your normal living expense that you would have otherwise incurred, I now provide that for you. So instead of you traveling, well, I come and fetch you and I take you and I drop you and I do everything. The value of that can be added to your remuneration. So if there's ever a dispute about, let's say, what kind of severance pay, I can take the value of that payments in kind, add it to the actual cash that you earn, and that then is your remuneration. So that can happen, and that does happen very often. Any questions around that? I know I'm rushing. I'm just mindful of the fact that it's 1:45, but that shouldn't stop you from asking any questions. I do have a section here about collective discipline. This is where it's the same misconduct, and the method is all the same. You can have one big hearing. The last time we attempted this was way back when in the day, city of Cape Town. What happened was the cops, they didn't like the municipal police force structure, because the cops, these are the guys on the motorbikes, they had a ranking system and they had all kinds of benefits, and this was, they just didn't like it, so they didn't want to go over. So what happened was they had a wildcat strike. So on this particular day, they decided on the N1, the N2, the M3, and all the other major ways into Cape Town, they would drive at 20 kilometers per hour starting at 6 o'clock in the morning, and nobody could pass them. And this caused a huge traffic jam. This was a protest action. One of the persons who got caught in that traffic jam was Helen Ziller, who flew in from Joburg for an urgent meeting and this, that, and the other. You can just imagine, by the time she got to the Civic, all the lawyers had been called in. And what we found was the following. They, not just to make sure that you couldn't identify who they were, and all the vehicles were more or less the same, they took their number plates off. You try driving without your number plate. I mean, it's crazy. They did it. They took off their license discs so that we couldn't identify. The only way we could identify which vehicle it was that little micro dot story, and they printed on the windows, and so we were able to then see Yasmin, who used to work for Helen Ziller. That was the only way that we could find out who they were and which vehicle was which, and so we could know which driver was attached to it. Now you're going to say, well, why don't you just take photographs? Well, they all got the snores, they all wear helmets, and it's impossible to tell them apart. So eventually there were some differences. They don't all look alike. But okay, we're going to run one big disciplinary inquiry for 160 cops. Yeah, didn't quite work out because some were on the N1, on the N2, on the N3. So eventually we were forced to run individual inquiries. But as a concept, if the discipline and the misconduct is all the same, then you can have one big hearing for 160 people. The test is whether or not in those circumstances faced by the employer, individual or collective hearings is warranted. We've dealt with the Constitution, the right to strike versus the right to lockout, just to emphasize the point that these are the polar opposites, but you will, in the Constitution, you will only find protection for the right to strike. That is simply because CASATU at the time of the drafting insisted, and they said we had to sacrifice so much more to get our right to strike, whereas the right to a lockout was always there and was always enforced by the employers. So they then insisted that it be excluded. It means nothing, but it's just one of those things. Other interesting areas of the Constitution, the common law versus the LRA. So this is now before Archer's decision, common law versus the LRA, what the Labour Appeal Court said, the Constitutional Court said, you've got to choose one, and once you start off in the LRA, you can't, in the middle of the race, jump ship onto another horse and then back the common law. You've got to finish one, and when you finish that one, then you can go the other way. Alec Freund tends to think that it could be a parallel process, and Archer certainly seems to suggest that it could be a common law and a LRA process that could be entertained simultaneously. What about other irregular employment rights? So SWET, this is the Sex Workers Education Advocacy Trust. There was a case around it. Let's say you want to take off on a Sunday and you work for a brothel. Sundays are apparently a very busy day, I don't know. But the woman wanted to spend some time with her kid, and the owner said no, and they dismissed her, and she took that case on. The ultimate decision was that because the aim and objective of that contract of employment is still unlawful, which is why SWET is pushing for the regularization of prostitution and negotiable sex and negotiable affection, so that it just be regulated like any other normal contract. If you think about it, is there really a victim, a consenting male, a consenting female, or two consenting males? It doesn't really matter. Should we still be excluding that for these, let's put it in inverted commas, victimless crimes? But then where do you draw the line? What about the tick dealer, the unreasonable tick dealer who fires the little minion for not selling enough tick lollies? There is a victim there, the person who's buying the tick lollies, so that would still be no longer protected or won't be protected. But that's the kind of thinking that you guys are going to come up against in the future. Is this really something that we should be still excluding? Some of the non-litigious stuff, just as an example of the kind of topics that we deal with: cell phone usage, tables. The tables are, first warning, second warning, third warning, that sort of thing. Motor vehicle usage policy. Even if it's your vehicle, if I stick my name on it, you must drive like a normal person. You can't drive like a taxi driver in rush hour. You've got to obey the rules of the road. Computer usage, almost anything I can regulate in the disciplinary code and procedure. There's a movie called American Gangster with Denzel Washington, and he was selling product. He was a drug dealer, and his product was always getting stolen. So what was his terms and conditions? One of the things that he put in there was that nobody can wear any clothes. And that was it. That way he reckoned if you get away with it, if you still steal from me, you probably deserve it. But just to underscore the point, that's obviously a ludicrous example, but almost anything can be regulated by that. Denzel Washington in that scenario could come, and I could have written up a policy and procedure just dealing with that. So you wear clothes to work, you could get dismissed. Quite ridiculous, you would agree. The common law, what I can deal with there, your duties, service. So where you've got a duty of service, that implies that you can do it. I don't have to actually specify that you can do it to a certain level, because that's just dealt with in my employment standards. Good faith, you can't come along and work for me and then also work for the guy next door. That's bad faith, because you only have your service is to me. Subordination, you've got to subordinate yourself. What does that mean? It means that you can't come and when my back is turned, you fluke me 8. Yeah, the slippery flow, yeah, that's certainly it. I was just using it as an example to get you thinking around those things. The point being simply that it doesn't automatically follow in this day and age that every single illegal activity would suddenly be excluded. You've got to ask yourself those questions, and it's when you ask those questions that you advance the law. Competence is implied. My duties as your employer is literally to pay you and to keep you safe, but that arises from the law of dealing. I don't have to actually give you a stitch of work. I can make you sit in the corner. I could end up with a constructive dismissal claim, but I don't actually have to give you work unless, of course, you have a contract of employment that says you will play Hamlet in the play. There I've got to give you that role because that's what your contract of employment says, that you will play Hamlet. But if you don't have a contract that says that, then I don't actually have to do anything. I just have to pay you. Restraints of trade, still very much enforceable. It requires what we call a protectable interest, and there's a lot of litigation about what constitutes a protectable interest. We will all agree that my customer list and you know, your personal interest, whether you like whiskey or brandy or wine or whatever the story is, that's confidential. You know, I'm entitled to protect that information, and I can use the restraint of trade in doing that. If I invent things like, you know, more or less what kind of hourly rate goes for what matter, and I've got a, you know, an algorithm that helps me determine how much to charge the maximum, I can protect that algorithm by the restraint of trade and my confidentiality. Geographic limitations still apply. In my day, it used to be 5 years, whole of South Africa. That's not going to work, because where else are you going to go now? You've got a green mamba South African passport, you know, you're going to go work in Namibia, you know, it's probably covered there as well. So geographic limitations within reason. If you're based in Cape Town and I'm based in Cape Town, and I can maybe protect Cape Town, but I can't really protect Bellville and you know, Malmesbury or Joburg or any of that. I can't stop you from working there. Time limitations work. When I started out, like I said, we were dealing with 5 years. We're now talking 6 months to a year. Maybe it's not just a Sumasu thing. It's not there for the taking any longer. It's only, you can only do what is reasonable to protect your protectable interests. After that, it's no longer protectable. You can have the anti-poaching stuff. What's the anti-poaching stuff? If you leave my employees, leave my secretary, leave my PA and my paralegal alone, that's anti-poaching. So if you come and you get my secretary to come and work for you, lure them across with lots of money, I can interdict you and I can force you to pay me damages for training up a new secretary at 200 words a minute. Confidentiality undertakings, eminently enforceable. So yes, if you email me, I'll email you this confidentiality undertaking. It's something for you to work with. It's not going to appear like this in your contract, in your question. There could just be, for example, a different confidentiality undertaking, and you have to discuss whether or not it's enforceable. And in there are things that are clearly not enforceable. Same with a restraint. Is there a protectable interest disclosed in here? Is the time period appropriate? Is the geographic limitation appropriate? You email me, I will send you those examples, and you can then use that as the basis. We have been through these case studies. I'm just going through them. We have to talk about Section 198 of the Labour Relations Act, and there are 4 sections that are applicable there. The first one deals with labour brokers, 198 capital 8, and what it says is that after 3 months there's joint and several liability with the primary employer for any staff employed on a temporary basis for a client. So that's 198 capital A. What does that joint and several liability means? in essence, the terms and conditions of employment on the whole must not be less favorable when you are performing work of a similar nature. So if I hire you a professional assistant and there's 2 or 3 of you, and I hire a temp, what you call a locum attorney who comes in via another agency, comes to work for me for 3 or 4 months. In that time, after 3 months, their terms and conditions of employment can't be any less favorable than your terms and conditions, providing they're doing work of a similar nature. It is a bit of a bad example because you don't get attorneys coming in on a sort of a temp basis any longer, but they used to exist. They used to be quite the rage in way back when in the day. The exceptions, obviously the seniority. I've been doing this for 23 years. So if you come in as a temp or a PA or whatever the story is, I'm going to earn more than you because I've got more seniority. I have the quantity and the quality of my work is much more than and better than yours. I know more. But if we are, I don't know, both making cakes, you know, you're a baker, I'm a baker, and my cakes taste as good as yours, then doesn't really matter. Section 198 capital B, fixed term contracts. Fixed term contracts are still permitted. Now here's the kicker. If you are earning more than 205,433 Rand per year, which works out to roughly 17,450 Rand, anyone earning under that is protected by 198 A, B, C, or D, and they can rely on those sections to try and gain permanent employment. If you earn more than that, then you are excluded from the protections of 198 capital A, B, C, and D. So fixed term contracts, if I pay you 20,000 Rand a month, then I can appoint you on a fixed term contract of 6 months. And I can see how you do and I can confirm you or not after that. But if I pay you 17,000 Rand a month, after 3 months, you become permanent. Now, what are the exceptions to it is if I'm just bringing you in on a 6-month contract to, for example, replace somebody who's on maternity leave. If I've got a piece of work, a case that is going to finish as soon as the last witness testifies, then I don't need you after that. It's called a job lot. There's a specific job that needs to be finished. I can bring you in on a contract and pay you less than 17,450 Rand, and I can get away with it. So still there are exceptions, and I'd encourage you to look at the exceptions provided for in section 198 capital B. I don't know if that's probably too detailed to find its way into your exam question paper, but you never know. Part-time workers. Part-time workers, what we try and do with the part-time workers is to make sure that they get to qualify for permanent full-time employment. So I can hire you as in the old days they used to call it, for example, a Girl Friday. They just come in on a Friday, help with the admin so that everyone can leave at 3. So what I've got to do for somebody who comes in on that sort of part-time basis is to try and create opportunities for them to get permanently employed. And that is a real thing, and it's regulated in section 198 capital C. 198 capital B, fixed term, unless the work is on a limited or definite duration. Example, the picking season or something like that, and the employer can justify why a fixed term contract is needed. You can go with fixed term. Otherwise, it's an indefinite contract, and an indefinite contract is permanency. What is the justification for a fixed term contract? You're replacing someone temporarily, a temporary increase in the work, job training for recent graduates. Example, you guys, CAs, this is just a job training for you. It's not a permanent position. It could be project work, it could be work permit for a fixed period, seasonal work, public work scheme. If somebody else, for example, it's an NGO, and the NGO wants you to, I don't know, do a census in Khayelitsha, and they will pay for that census. When that funding runs out, so too does your job. You could be a retiree hired on a fixed term basis. So that more or less is the lay of the land on 198 capital B part-timers, and that's 198C. Got to treat you the same except for the hours, and I've got to move or assist you to help you get permanency. So that's the lay of the land, more or less. It's the end of my slides and the end of my lecture. But are there any questions? I know we rushed through that last part, but I'd encourage you just to have a look at 198 and see where it is. The SA Labour Guide, look where there's opinion stuff, where you want information. For example, what do I need to do to issue a subpoena? That's information. It's not